appropriate balance to the protection of our civil liberties and human rights. Thank you, Mr. Chair.
Call Tim McIndoe.
I'm happy to assure the previous speaker that the rights of law-abiding citizens are not infringed by this bill. In fact, on the contrary, this represents a very elegant solution to a significant problem and one that is of considerable public interest. I too would like to join my colleague Dr. Calder in commending our new Minister of Justice for the considerable body of work that she has done on this bill since she assumed her new portfolio, and for the very detailed supplementary order paper that she's produced to respond to some concerns that had been made apparent to the Select Committee when it looked at the earlier version of it. The important thing is to ensure that we get that right so that the provisions and the impact of the bill are appropriate in the modern context. Mr. Speaker, I'm very happy to speak on Part 1 of the bill. The previous speaker has just referred to Clause 4A, which is the purpose of the bill, and it's important to have that clearly understood, that the Search and Surveillance Bill will provide a comprehensive regime of search and surveillance powers under a single statute. And let's not underestimate how important that is, because the many bills that have existed and have come together in a piecemeal fashion over 5 decades now had become, as the Law Commission pointed out, a bit of a jumbled mess, and it was the Law Commission who recommended, in fact they urged in 2007, during the period of the previous government, that there should be one bill to bring order, certainty, clarity and consistency to the sprawling mass of statutory powers of search and surveillance which were scattered throughout the statute book. And the Law Commission identified a need to address the glaring gaps where the law has failed to keep up with changes in modern society. And we all know that it is a vastly different society, even from 10 years ago now, with the rapid speed of technological development. It seems that every year there are new gadgets, there are new openings, new possibilities for things that could be, as Mr. Bridges is pointing out, in the wrong hands, used to ill effect. And so we need to ensure that our laws are relevant, but also, as Dr. Calder has pointed out, that we are mindful of the human rights provisions, the important human rights of all law-abiding citizens. I have to say I don't have a lot of interest in the human rights of those who are not interested in obeying the laws, because quite often they threaten our safety, our security, our homes, our elderly, the vulnerable in our society, and everything that we can do within lawful means to give our law enforcement agents the ability to apprehend them is vital. So, Mr. Chair, the Search and Surveillance Bill consolidates police powers from several different pieces of legislation as well as case law. There are also some new powers such as examination orders, production orders, surveillance device warrants, and a warrantless power to preserve evidence of serious offences punishable by 14 years imprisonment or more. Now, those are very serious offences that we're considering here, and we need to be mindful of just how important it is for us to deal with them, to provide our law enforcement agents with the ability to apprehend such significant criminal offending. But these new powers are balanced by safeguards to protect human rights and the right to privacy. How does it do that? Well, my colleague Dr. Calder began to speak about that. The bill explicitly states that its purpose is to balance law enforcement and investigation powers with human rights values. And there are a number of significant safeguards in the bill to deal with that, and I'm sure that those who are listening will be reassured by this. First, the bill adheres to the basic concept that independent authorisation is needed before exercising search powers. Enforcement officers must justify the exercise of search powers to neutral issuing officers. Secondly, there are detailed reporting requirements to the issuing officer, the chief executive of the relevant agency, and to Parliament on the exercise of search and surveillance powers. These allow search powers to be monitored to ensure they are being used properly and not being abused. And, as Dr. Calder mentioned, the Act will be reviewed in 2016 to ensure it's operating properly. So quite a number of reassurances and safeguards there. And thirdly, the bill doesn't affect New Zealanders' right under the New Zealand Bill of Rights Act, which was mentioned by Mr. Clendon a few minutes ago, to be free from unreasonable search and seizure. There are other safeguards in the bill which include enforcement officers who make false search warrant or surveillance warrant applications can and will be penalised. More serious powers, such as examination orders, may only be authorised by judges, not just by any issuing officer. Issuing officers from an agency can't issue warrants to enforcement officers from the same agency to ensure neutrality and impartiality.
The Honourable David Parker.
Mr. Chairman.